Juan de la Cruz was convicted for a commission of crime punishable under Republic Act 9165, otherwise known as Comprehensive Dangerous Drug Act of 2002, and imposed upon him a penalty of an indeterminate sentence of 4 years of imprisonment as minimum to 8 years as maximum. He applied this case to Court of Appeals, which reduced the sentence to 3 years as minimum to 6 years as maximum.
Is Juan de la Cruz qualified to apply for the privilege of probation? Give the legal basis on your answer.
Yes, anyone can apply for a probation. However, the benefits of this decree shall not be extended to those A. Sentenced to serve a maximum term of imprisonment of more than 6 years. Letter B. Convicted of any offense against the security of the estate. Letter C. Who have previously been convicted by final judgment of an offense punished by imprisonment of not less than 1 month and 1 day and or a fine of not less than 200 pesos. Letter D. Who have been once probation under the provision of this decree. And letter E. Who are already serving sentence at the time of substantive provisions of this decree became applicable pursuant to Section 33 hereof.
If ever the violation of Juan de la Cruz was found committed under RA 9165 is drug pushing, will your answer be changed? Justify your answer.
Yes, because if Juan de la Cruz was found to commit drug pushing, then he is not qualified to receive probation, even though anyone can apply for probation, provided those who are exempted from it. Juan de la Cruz cannot apply for the privilege of probation because it was stated in RA 9165 or the Comprehensive Drug Act of 2002. Section 24, not applicability of the provision law for drug trafficking and pushers, that any person convicted for drug trafficking or pushing under this act, regardless of the penalty imposed by the court, cannot avail of the privilege provided by the provision legislation or the presidential decrees as amended. It is also stated in PD 968 that any person convicted for drug trafficking or pushing, regardless of the penalty imposed, cannot avail of the privilege granted by the provision law of PD number 968.
What if Juan de la Cruz is considered a first-time minor offender under RA 9165 and the decision of the Court of Appeals is to sustain the penalty of 4 years to 8 years of imprisonment? What could be your answer regarding his qualifications for probation privilege?
If Juan de la Cruz is considered a first-time minor offender and the decision of the Court of Appeal is to sustain the penalty of 4 years to 8 years of imprisonment, then he can be granted probation under RA 9165, known as the Comprehensive Dangerous Drugs Act of 2002, Section 70, probation or community service for a first-time minor offender in lieu of imprisonment, stated that upon promulgation of the sentence, the court may, in its discretion, place the accused under probation, even if the sentence provided under this act is higher than the provided under existing law on probation, or impose community service in lieu of imprisonment.
If Juan de la Cruz was sentenced before the effectivity of RA 10707, is he qualified for privilege of probation law? What are the implications of RA 10707 to Juan de la Cruz application for probation if it's still pending for court's decision?
In Section 4 of RA number 10707, that when a judgment of conviction imposing a non-probationable penalty is appealed or reviewed, and such judgment is modified through the impositions of probationable penalty, the defendant shall be allowed to apply for the probation based on the modified decisions before such decisions becomes final.
The application for probation based on the modified decision shall be filed in the trial court where the judgment of conviction imposing a non-probationable penalty was rendered, or in the trial court where such case has since been re-rappelled. Hence, if Juan de la Cruz was sentenced before the effectiveness of RA 10707, he could not apply for probation.